Well, our first speaker today is David Harris. David is the co-chair of the Commercial and Business Litigation Practice, as well as the Intellectual Property Litigation Practice of Lowenstein Sandler in New Jersey. David successfully defended David Chase in a jury trial against a claim by a former judge that the judge helped Chase create the HBO series The Sopranos. David also won a jury trial, attorney's fees, and treble damages in a patent infringement case involving electrical products. David is recognized in Chambers USA, America's Leading Lawyers for Business, the Best Lawyers in America, and Super Lawyers. David has been profiled in the ACLU Civil Liberties Reporter and has been a keynote speaker at Rutgers Law School. Please welcome David Harris.
I'm going to talk to you this morning about trade secret audits. And the reason I chose this topic is over the last 5 years, trade secrets have become increasingly important, and for a number of reasons. Back in 1979, the Uniform Trade Secrets Act was, the uniform law was adopted, and now, as of 2014, 47 states, including the District of Columbia and all of the U.S. territories, have adopted the Uniform Act. Now, New York City is one of the outliers. New York State is one of the outliers. It is pending in Massachusetts. So pretty soon, all 50 states, the district, and all territories will have adopted it. In 1996, the Economic Espionage Act was enacted. Now, the Economic Espionage Act is a criminal statute. There have been several prosecutions under this statute, but it only involves trade secrets that are taken and given to a foreign company. So it is limited in that it's a criminal statute and a foreign company or government must be involved. Actually, last month was the first jury verdict under the Economic Espionage Act. And the guy who was convicted will get 20 years. In addition to that, there's the American Invents Act that was adopted in 2010. Now that principally deals with patents, but in that act, one of the provisions is that if you have a trade secret and you had that trade secret before and were using it before the patent was filed, even after that patent is issued, you will not be an infringer. So you not only have an absolute defense against that patent, you also are allowed to continue to use your trade secret without paying a royalty. In addition to that, the Supreme Court in this term has issued several decisions regarding patents that, in the view of many patent practitioners, that have weakened patents somewhat. So many companies now, when they have a technology, they are considering whether to patent it or to keep it as a trade secret. Now, in 2012 and in 2013, Congress began considering what is called the Protecting American Trade Secrets and Innovation Act. Not surprisingly, Congress hasn't passed this yet. But if they do, where there is nationwide service of process required or a foreign company is involved, there will be federal jurisdiction. So all of these things together are creating momentum for trade secrets, and it is important that companies recognize it, get ahead of the curve, and begin auditing your trade secrets. The FBI has identified economic espionage and the theft of trade secrets as the #2 priority, just behind terrorism. And this is a quote from the FBI website, and I would, for today's talk, they talk about increasingly linked to the insider threat. And that insider threat is employees, joint venturers, collaborators, vendors, anyone who may be either developing or exposed to your trade secrets voluntarily. They're no longer the poor second cousin. Because of this federal legislation, you really have to identify your trade secrets. And interesting to me, I think it was at our last seminar, we were in Camelback, Arizona, and there were a couple of venture capitalists in my breakout session, and they told me that when they're acquiring companies or investing in companies, not one company has ever identified trade secrets. And they always ask for them, and no company has identified them. So these are the people you have to watch out for, because today's collaborators will be tomorrow's competitors. In the written materials, I refer to an article that lists all of these more recent collaborations turned competitors. And sometimes the non-disclosure agreements, if they're not thorough enough, are not adequate. And that's just the beginning. Now, how do you know you have a trade secret? Not until it's litigated. It's kind of like, the judge has to tell you. It's sort of like what Justice Powell said about pornography. So for those of you who are getting bored right now, just use your imagination as to what a trade secret, how it is similar to pornography. Not too much, though. Now, the importance of this is, and this is an important decision point, when you have a patent, or you have a trademark, or you have a copyright, or any other intellectual property, when you get the certificate from the government or the patent is issued, then you know you have a patent, or you know you have a copyright or a trademark. A trade secret, you don't know what it is, and it's unusual things. Public information collected and used in a unique way is a trade secret. Customer lists can be trade secrets. These things are not usually among employees. They don't think of them as something as valuable. Now, this case was just decided on July 14th of this year. And let me tell you a little bit about it. It's Hallmark Cards versus Monitor Clipper Partners. Now, Hallmark paid Monitor Company Group $3.2 million to do some research on the greeting card industry. Now, Monitor Company Group is a separate company from the defendant in the lawsuit, but it had common ownership. The business plan of Monitor Clipper was to use the customer base for its marketing research group to cross-sell the private equity company. So Monitor presented its research in 5 PowerPoint presentations to Hallmark. 4 years later, the private equity company asked the marketing research company for the presentation, and they sent it to them. Now, there was a very thorough non-disclosure agreement, secrecy agreement, and Hallmark had never disclosed its research. They did in some public, they made one statement about women over 45 are no longer using greeting cards or something like that. But the core of its research was never disclosed. Clipper used the information from the PowerPoint to win an auction of a company that was in bankruptcy that was a competitor of Hallmark. And they also used it to help get the financing to buy that company. So there was an arbitration clause between Hallmark and Monitor. And at first, the arbitrator only gave Hallmark $3.2 million, which it had paid, and $900,000 in case any other trade secrets were conveyed. It also ordered a forensic search of Monitor's computer because they had wiped their hard drives during this process. They found 2 emails. The 2 emails sending the PowerPoint presentation to the private equity company. They came back, and from $4 million, the settlement in the arbitration was $16 million. Then they got a verdict against Clipper for $31 million, including $10 million in punitive damages. Now, Clipper argued on appeal 2 things. Hallmark had published the secret, and 2, that it was 4 years old and it couldn't be secret anymore. But Hallmark had kept it secret that whole time and had not disclosed it. So the 8th Circuit last month affirmed the $31 million verdict. For PowerPoint presentations, they got $47 million for PowerPoint presentations. So trade secret audits allow your company to be in the position of Hallmark. Now that is a systematic process, so let's talk about it real quick. Number 1, you need a lawyer who is familiar with trade secret litigation, but only one. Don't use a corporate lawyer. I can't tell you how many agreements I have seen where companies convey or share trade secrets, and then the agreement says, and you shall maintain the secrecy for 5 years. A trade secret is good forever if you keep it secret. If you enter into agreements that puts a sunset on those secrets, you lose them. And I saw that just last year. It's painful. The rest of the audit team is your own employees, and they can be anybody depending on your business. These are some basic questions to ask, and I presented them in the way that if you're dealing with employees who have work experience, this is the easiest way to identify your trade secrets. What is it that could hurt my business if my competitors had it? And how much would it hurt? Whom do you ask? Now, it's important not just to ask the executives or the managers. Ask the employees who actually work with these secrets every day. Because protecting trade secrets is protecting their job security. The third question you ask is, what policies and methods am I using today to protect my trade secrets? And that's an important process to go through because it is the key element in every litigation. And then the question is how. Now, not all trade secrets are the same. Marketing plans, and you can see the list here, marketing plans, plans to hire a new executive, a rollout of a product, and so on. Engineering designs, manufacturing know-how. Those things they live forever if you protect them. Sources of supply. If you took a long time or you've tailored a source of supply to your specific needs, that's a trade secret. Now there are permanent trade secrets, temporary trade secrets, and then you have trade secrets that have to be absolute lockdown. These are the crown jewels of the company. It may be a source code, it may be a formula, I don't care what it is, identify it and put that subject to extra secrecy. Now, I was telling a client 2 months ago, separate file cabinets. He started laughing because nobody keeps anything in physical form anymore. Separate passwords for trade secrets, changed frequently. No off-site transmission, if that's practical. Lockout employees about to be terminated. I remember I had one case a few years ago. They were terminating this employee. Somebody from HR walked her back to her office so she could get her personal things, and she's at her computer. And she says, I just have to do a few things. And she was forwarding files of research to her personal computer. And okay, now we have to go. Oh, I just got to lock them out before you terminate them. No laptop use for the lockdown trade secrets, if that's possible. And I know for salespeople and executives, sometimes you have to do it. Block out downloads. The employees have to be educated. That's the job of the audit team and management. Management has to be behind this audit. You need to emphasize the importance of the audit. This third bullet point is crucial. Educate the employees, involve the employees, re-educate the employees, and remind everybody about the importance of trade secrets and which are the trade secrets and how they are to be disclosed and who has access to them. You need non-disclosure agreements, and involving the employees helps with the non-disclosure agreements because now they understand why. And you keep emphasizing protecting your trade secrets is protecting job security. You also want to update your employee handbooks. You value trade secrets. You can value them a number of different ways. The tried and true way is you keep track of how much time and money and resources you've spent, how many trials and errors you've had before you came up with the solution, the number of people and other resources involved, and you document the competitive advantages. Sometimes that's increased sales, sometimes you get a lead on your competitor in a product area, you document that. This enhances your success in litigation, adds value to your company if you're going to merge or be acquired, and it is easy to prove damages. Now, going back to the Hallmark case, they used 3 methods of damages, and one was a discounted cash flow, and because of all of the increased sales and management of the private equity company were attributed to the trade secrets because they used them so thoroughly. They also, in that case, they got damages for the disclosure, the wrongful disclosure of the trade secret, and then separately for the use of the trade secret. You can do that when you have a well-documented trade secret portfolio. Now, let me sum up. Sometimes doing a trade secret audit is a barrier or it's an administrative burden. But when you do it ahead of time, it's not only saves you time, it saves you genuine heartache. When you have to look back and you can't protect your trade secrets because you didn't identify them, protect them, and value them. And it is a key element to the protection of your business, and it's going to become even more key as we look forward to the future. Thank you.